I'm Benjamin Beck. I am a consumer protection attorney in California. I've been practicing over 12 years, and I've worked for two of the largest lemon law firms in the state of California. I've dedicated my career to lemon law. I've litigated over 1,000 cases against all of the major auto manufacturers. I've tried more than 15 cases to verdict at jury trial. And some of those cases I was able to obtain the maximum recoverable at law. And I founded the Beck Law Office in furtherance of the goal of advocating on behalf of consumers who are wronged by large auto manufacturers. And I created this video to kind of answer some of the questions I receive from clients and colleagues. The Beck Law Office, first off, I'll let you know, is located in Los Angeles. If you do have any questions, feel free to give me a call. I'm at 213-567-4501 or available by email at ben@becklawapc.com if you'd like a free consultation or you have any questions following this video. But getting back to the reason I created this video, it's really to answer the question of what is a lemon? So many of my potential clients or colleagues are curious or think they might have a case. Really, one of the big benefits before we get into what is a lemon is why this lemon law was created. And the reason it was created was really to protect the consumer. Because before the lemon law was in effect, consumers would have to hire a lawyer and pay out of pocket, which was often discouraging to them. Because lawyers cost money and they didn't want to spend the time or have the resources to spend the money on pursuing a case in court against a huge auto manufacturer that's worth billions of dollars. So the lemon law came about and required that the manufacturers pay the consumers attorney's fees, which is a huge turning point. And now to this day, consumers aggrieved by manufacturers that have sold them a lemon vehicle are required to pay that consumer's attorney's fees. So that's a huge shift, and it really incentivizes consumers to seek justice when they deserve it. And it also encourages manufacturers to do the right thing and buy a car back when it qualifies as a lemon. Now, getting into what is a lemon, one of the things that you have to determine is, well, look, is this a new car? Now, the law recently changed, and new cars are really, as it is right now, the only cars that are protected under the California lemon law. And so there must be a new vehicle, there must be a defect. And what is a defect? Well, it must be something abnormal, some sort of nonconformity in the car, truck, or SUV that left the manufacturer in a substandard situation, or the substandard defect manifested at a later point during the ownership. And that defect must be one that is covered under the manufacturer's warranty. The example that comes to my mind is sometimes tires aren't covered under the auto manufacturer's warranty. Rather, they're covered under the tire manufacturer's warranty. So it's got to be a defect that's actually covered under the auto manufacturer's warranty. And it also must be a substantial defect. We're not talking about insignificant things. It must be a substantial impairment to the use, value, or safety. And what does this mean? Well, use, a lot of things that the defense attorneys and the manufacturers will look at is, are you driving the car on average fewer miles than you drove it before you had the defect? Are you not taking on the trips that you plan to take it on because of the defect? Are you not driving the car at all because of the defect? Have you driven a different car? Or are you driving an alternative form of transportation or taking taxis or Ubers or something like that instead? So that's how it's often looked at to determine if the use was substantially impaired. Next, the defense often looks at, and the manufacturer will determine if the value was substantially impaired. And I'm not talking about $1 or $2 here because of the defect, but because of the defect, is the car significantly less valuable? Has it been diminished in some way? And a lot of ways to go about this, but was there an appraisal that determined the value was lower than what it was when it was purchased? or it was a trade-in value. Maybe you tried to trade in the car and they were giving you less in trade-in value because of the defect. Maybe you did your own research on Kelley Blue Book or Edmunds or one of those other pricing guides. And the value must be a substantial change, a substantial diminishment. And the other kind of the big one is safety. Was there a substantial impairment to the safety? I mean, did the engine cause it to stall on the freeway? Are the airbags, malfunctioning? Are some of the safety features in the car not working correctly? For example, automatic braking systems. Are they coming on spontaneously without any obstructions? So these are the things that you kind of have to look at to determine if there is a substantial impairment to the safety of the car. And then next, the manufacturer has an opportunity to repair it. They have a reasonable obligation to repair the car, meaning they need to fix it within the warranty after a reasonable number of attempts. Now, this means more than one repair opportunity or repair attempt, but each situation is a little different. Depending on the severity of the defect. If you're dealing with a safety defect, you might not need to bring it in as many times to give them an opportunity to repair it. If it's a known issue with the car, you may not have to give the manufacturer as many opportunities to repair the defect. But you do need to give them a reasonable opportunity to repair it. And then lastly, you need to have purchased or leased the car. If you're the primary driver or you're not the owner, you really don't have standing to kind of sue. Realistically, if you're making payments, there's some wiggle room there. If you're the one making the payments and somebody else purchased it for you for credit purposes or things of that nature. And then lastly, if they didn't buy the car back from the manufacturer when they're supposed to because it's a lemon, you might be able to recover additional damages in the form of a civil penalty. Now, what do you get when your car is a lemon? Well, you're entitled to a refund. Now, there's some deductions that I won't get into here under the lemon law, like a mileage offset and things of that nature, but essentially it's your money back. And if you can demonstrate that the manufacturer knew that the defect was, that they knew about it, that it was a lemon, and they didn't buy it back despite knowing that it was a lemon, they might be on the hook for a civil penalty, which is a willful failure to comply with the law to buy it back. And if you're able to recover or demonstrate that you're entitled to a civil penalty, you're able to recover up to twice the refund amount on the car. So that's really to kind of, along with the attorney's fees, to encourage the manufacturers to do the right thing and buy lemon cars back when they qualify. In any event, if you have questions about this or you have a case and you're watching this video because you might believe your car is a lemon, give me a call. Again, my phone number 213-567-4501, or you can reach me by email, ben@becklawapc.com. You can also reach me on my website, www.becklemonlaw.com. In any event, I hope this video has been informative for you. Please be sure to subscribe below so that you can stay apprised of any new developments or any changes in the lemon law or stories about some interesting cases I've had down the line. Thank you very much.